there was obviously dispute on whether or not her facts that she alleged were necessarily totally accurate. But it was, the case involved a 5-year-old little girl that was out on the playground, was allegedly thrown to the ground, was hit by some of her coworkers, and allegedly held down, and her dress pulled up and her underwear panties pulled down. And all the other children there watching and laughing, mocking, that type of thing. That was her version of the events. And that some of the children were, even poking and touching and different things like that. Poking her shoulders and, and mocking her. Horrible set of facts. The parents sued the school. She went home and told her parents what happened. And the parents sued the school. And again, it went to the Supreme Court on whether or not there was negligence out there on that playground when that incident happened. The parents said that reasonable care was not provided in the supervision. Now, in that lawsuit, though, the Supreme Court said, we recognize that things are going to happen, but we're going to establish what the standard is as far as whether or not a teacher did or did not do their job. This is the standard. They said that you are required and you have the responsibility. I'm going to say a lot of words here and then we're going to break it down. You have a responsibility to use ordinary care and to take reasonable steps, ordinary care, and to take reasonable steps to minimize the foreseeable risks to students, thereby providing a safe school environment. I know I just said a lot. We're going to talk about that, and I'll break that sentence down. But again, that you are required, the courts say, and you have a responsibility to use ordinary care, and to take reasonable steps to minimize the foreseeable risk to students. Okay? Now, ordinary care. What does ordinary care mean? How do they define what ordinary care is? Ordinary care, we're not talking about extraordinary care, but you are required to take reasonable steps to ensure that children are safe. Reasonable steps to ensure that the children under your charge, that they're safe. Also, ordinary care, the court stated, means that the school's internal policies and procedures were followed concerning that supervision. It's kind of assumed that the internal policies and procedures of the school will provide ordinary care, will show ordinary care, reasonable steps taken to provide that supervision. So the first thing that the courts want to see is, did you, in that circumstance, follow your school's policy and procedure as far as providing the supervision for those children, whether in the classroom setting, whether outside on the playground? Did you follow the school's policies and procedures? And the standard for ordinary care, objectively speaking, means would a reasonable person have done more to ensure that risks were minimized? Would a reasonable person have done more to ensure that risks were minimized? Like I said, things happen. It happened like that. Stepping back after the fact, it's a matter of looking at the situation and determining, what could more have been done here to prevent this injury? Things are going to happen. I know that. But could something else have been done to prevent this from possibly happening? It doesn't require that extraordinary care, but only ordinary, reasonable care and precautions have got to be taken. If I was a plaintiff's lawyer, and I got to stress this a lot, I'm a defense lawyer. I represent folks who are sued in the state of Mississippi. If I was a plaintiff's attorney, though, and I had a child that came in with some parents and said, listen, my child was injured at school, something happened, they were bullied at school, or they hurt themselves on some equipment or something like that, and they wanted to explore litigation for negligence by that teacher, the very first question I would want to find out is whether or not the school's internal policies and procedures have been followed. Because if you don't follow your school's policies and procedures, I can tell you, it's going to be a difficult situation to defend if somebody gets hurt. Because the first thing that the courts are going to want to look at, that I want to see, is did you follow your school's own internal regulations? Okay? Another important phrase in discussing the care that's required, again, in the Supreme Court's ruling, was that teachers have a responsibility to use ordinary care and take reasonable steps to minimize the foreseeable risk to students. The key phrase there is to minimize the risk. To minimize the foreseeable risk to students. Now, the court uses the word minimize. The court didn't use the phrase to eliminate. That's a very different thing, isn't it? And that's probably impossible. when you're dealing with 3, 4, 5-year-olds, it's probably impossible to eliminate all risks of somebody getting hurt. Isn't that right? And the courts recognized that, and they said that the standard of care is for you to take reasonable steps to minimize the foreseeable risk to students. To take steps to minimize the potential risks and injuries that your kids might get involved in or have happen to them. One other phrase that's very important here in our definition is to minimize what? The foreseeable risks. That's a key word here also, foreseeable. Ordinary care and taking reasonable steps to minimize foreseeable risk to students. You know, if you didn't have reasonable notice of a foreseeable potential risk, then y'all, that's not a foreseeable risk. You have to have been given reasonable notice. Now, if you glance over and you see out on the playground and you see that a piece of equipment is broken, something that the kids might climb on or slide down, and you see that it's loose, that it's rattling, have you been given notice then at that point that that's a potentially dangerous piece of equipment for them to play on? Absolutely. Now, nobody went up and told you, but you've seen it. You've got notice of it, okay? One of the key things in performing your duties every day is to always be asking yourself during the day, or at the end of the day, and again, many of you are very experienced, and you've been doing this for many years, and I understand that, and you're doing this already. Ask yourself, what have I been put on notice of today? What have I been told by one of my children today? What have I seen as far as the environment that they're in the classroom, or on the playground, the lunch hall, something like that? What have I seen about the environment that these kids are in that could potentially be a dangerous situation? Because if you've noticed something, folks, that's a foreseeable risk. Okay, that's a foreseeable risk. Have you noticed on a playground some aggressive behavior by one particular child or by a group of particular children, and towards maybe a bullying towards one individual? If you've seen that, you've got notice of it. And the first question that a plaintiff's lawyer is going to look at is, did you follow your own policies and procedures? And number two, did you have foreseeable notice of a risk of some injury? Have you seen or have you heard complaints from children about maybe physically aggressive behavior by other kids? Are you aware, do you have some kind of notice that children are targeting one particular child? Has that child complained to you? Has that child's parents, have they come to you and complained? Are there circumstances where you got notice that requires you to take some action to minimize the potential dangers, whether it's a faulty piece of equipment or aggressive physical behavior by other children? Have you got notice that requires you to take some steps to minimize that potential risk, okay? In that circumstance, once you have noticed, the burden's on you, okay? And it's a serious responsibility for you. I've used the phrase a number of times here this morning already. I've used the phrase supervise a lot, that you've got to provide supervision, looking out for these foreseeable risks. The laws don't require just supervision. The law requires adequate supervision. Adequate supervision, okay? Is there a reasonable ratio of, as far as the number of children that are in your charge, is there a reasonable ratio between you and the number of children that you're supposed to be observing, monitoring, and supervising? Is that ratio 1 to 25? Is that ratio 1 to 22? Y'all, I can tell you in the St. Andrews case, the ratio there was 1 to 16. Okay? 1 to 16, which is a good number. And the court said, hey, that's great as far as that ratio. That's a good, reasonable number. But the issue there involving that particular teacher was whether or not that teacher was actually being attentive and providing that adequate supervision. Had they become distracted? Had they become unreasonably distracted? Okay? In that case, in the facts of that case, it was undisputed that that teacher was there and was out there on the playground. But it was also undisputed that when the injury occurred to this child, when these actions occurred, 10 of the 16 children that this teacher was to be watching